weekly Facebook Live, where we bring law closer to the people by teaching some insightful topics in very practical ways, so to say. So I'm Oluwasegun, in fact. I'm a lawyer with law accent. I head the firm's finance and technology law team. So today we are going to be talking about a very in the know topic. It's something that has been in the buzz for quite some days now. Everybody has been going on and on about it. Business owners, lawyers, major stakeholders in Nigeria's business industry, and it's the Companies and Allied Matters Act 2020, CAMA 2020. It's a new law that was passed into law by the President on the 7th day of August. That's this month. That was last week, Friday. So the passing of that bill into law, it brought about a whole lot of comments, analysis, legal debates, so to say, from various people, parties, from business owners, majorly, concerns on how this is supposed to facilitate. So recently, Nigeria moved up on World Bank's to the 131st spot. That's 131. It was like a big thing because it means like Nigeria's business environment has been developing. That index is based on how easy it is to start business in a particular country, how the business environment facilitates the starting of new businesses, and even foreign businesses, to go local and foreign. So Nigeria, it was quite a thing to celebrate, something to be celebrated, but on the reverse side, it actually is not, because that list comprises of about 190 countries. So we do not even meet the 50th percentile, so to say, if we are to calculate based on our actual performance. And going higher on that list doesn't specify or indicate any form of major economic accomplishments, so to say. So it doesn't say that your economy is better or things are going on pretty well for you. It's just a ranking on the ease of doing business. So, but the new CAMA has come into play now, and one of the major objectives is for it to actually facilitate the ease of doing business, of starting businesses, because the mandate at the beginning of the Act states that it's supposed to cover issues regarding incorporated companies, limited liability, incorporated trustees. So that's majorly like different forms of businesses that can be formed in Nigeria. So we're going to be going into some of the major highlights, some of them that have been introduced by the new CAMA, and hopefully by the end of this session you should know a thing or two about some of the innovative provisions that the CAMA has brought to play to facilitate Nigeria's business environment, basically. So the first one worthy of note that has been creating a very large buzz, it's like it's a big one for small business owners, and that's for the requirement for formation of a company. Previously, you need at least 2 people to start up a company. Basically, there must be at least 2 directors that form the company. But now there are single member companies provided for in CAMA. What this means is that if you intend to start your company without any partner or co-founder, so to say, that means you can do it alone, on your own. You register as the owner of the company, you make all the major decisions. So it basically just brings you the business company with the flexibilities of a sole proprietorship. A sole proprietorship is a business that is owned by one person. It's a one-man business. It's manned by one person. All decisions are made by one person. Profit is made by one person. So that's one that it brings. Although it brings flexibility of a sole proprietorship, it should not be mistaken for a sole proprietorship, because a sole proprietorship is a sole proprietorship, and single member companies are a form of companies. It's just that it allows for some form of flexibility, so one person can actually go ahead to start it. So you starting it doesn't mean you get some form of reliefs from tax authorities, so to say, because that was one of the major questions that someone put across to us about the tax implications of opening a single member company. So it doesn't change. Basically, all that has to do is in the form of opening the company, how you start the business, how you incorporate the company. So one person can do that. So that's one of them. The next one that I will be going into now is share capital. I will try to just touch here and there, but while being very precise, articulate, and very detailed too. So share capital. Many people saw this provision, but they didn't quite understand what it meant. They know it's a good thing on the face of it, because definitely it looks like the required amount is lower. And I'm talking about the share capital that is allowed for you to start up a company. So CAMA 2020 basically provides that for the minimum share capital for private companies now is 100,000 naira, and for public companies is 1 million. Is it? Yes. So on the face of it, you look like, wow, so we don't have to start our companies with million naira anymore, and it's all peachy, because for public companies before it was more. Now it sounds reasonable. It sounds small too at the same time. Like a public company, you plan to issue shares to members of the public, would that even suffice? But the provision is actually not in the amount. It's not in the price. It's in the use of words, the description of this share capital. So formerly we had authorized share capital. I will go into the differences between the two in a bit. We had authorized share capital, but right now in the new CAMA we have the minimum share capital. So authorized share capital, basically, let's look at it with one keyword: maximum. It's the maximum amount of shares that a company is allowed to issue, or the maximum amount that a company is allowed to issue shares in. While minimum share capital is the minimum. So instead of having like a ceiling price, the new CAMA basically just converted that and turned it upside down to a floor price. So you have at least, you do not have a maximum anymore. Because before, for you to register a company with above 1 million, you pay some extra fees, and you have to take into consideration the possibility of investors coming in later on, or giving out some form of ownership to others in the future. But then with minimum share capital, it's easier, because if you want to get more funding, you just basically have to amend like your memo to increase it. You go through the procedure for increasing the share capital, and it was done within 14 days. So instead of having like a limit, now you have a benchmark. So it doesn't go below 100,000 naira, and it's quite a good one, even for, especially when it comes to single member companies. So you just do it 100,000 naira and invest all the shares in yourself, all the ownership in yourself. But that's usually not practical, because you never can tell when it is you'll be open to investors, or you want people to come and invest in your business. So that's basically it for authorized share capital and minimum share capital. So the easiest way to authorized share capital sets the maximum price, while minimum share capital gives you a benchmark that you can't go below. So it goes as far as whatever. If you want to do 10 billion, it's your choice. So aside from share capital, there's now so the Nigerian business sector has been given into digital disruptions for some time now, but we've never fully taken it in. But I would say that the outbreak of the pandemic actually rubbed a whole lot in our faces. Like a whole lot of things that are supposed to be in place that are actually not in place. So the issue of having so many people go to CAC's offices nationwide and causing quite like, I wouldn't say a problem for them now, but crowd management, because basically 5 months of piled up work had to be handled within weeks. So one of our major flaws with business registration and all of that is the old analog system, getting to take papers every other time to the commission. So authentication of documents now, the CAMA provides that you can do that with an e-signature. This is like wonderful news for anybody that has registered a company before, because trust me, you know how it can be. You register, you get the forms, you sign it, then scan and send back to whoever it is that is registering for you. And if they should query the document, you may have to sign again. So the whole back and forth transferring documents between people for it to get signed and scanning and sending back again is like a whole lot of fuss just for business registration. But now an e-signature would suffice. That means there are lots of e-signature platforms. It could even just be you writing your initials in some font that you think best represents your style or something. But then an e-signature would suffice. You could sign off with probably your phone that has a stylus or your system that has a stylus pen. So that's one of the things. And then another part of authentication of documents that is quite thrilling is the fact that companies do not need to use seals anymore. It's not a mandatory thing. So where a document needs to be signed by a company, it would suffice if the director, secretary, or any authorized officer of the company just signs. So the issue of using seals every other time is a thing of the past now. So signing off a document would suffice, and there's no need to always execute company documents by deed, except where the law provides that they have to be executed by deed. And even with that, too, you actually going to put your seal on it. The whole seal thing is gone. It was already stale at some point. Because really, people think like, what's the point? If the directors are signing, why are we still sealing? If the person of the company is different from that of the directors and all of that. But then, signing off suffices now. You sign off the document on behalf of the company, and it's good to go. And CAMA goes as far as provided, because even though CAMA 2020 is a new law, there are lots of outdated laws in Nigeria. There's a whole bunch of them. So it goes on to say that if any other law provides that you need to execute a company document by deed or seal, that this new provision in CAMA actually overrides that one. So basically, signing off is like the big thing now. You sign off and that's all there is to it. And the sign off would even be an e-signature like I mentioned earlier. So one of the parts that, okay, this was based on feedback that we got here. So reservation of name, it was like more a thing of, so why is CAMA saying now that they can like reverse an already reserved name before they issue a certificate? They do it normally, yes. Anybody that has registered the company before that has had this issue before, they can. There's a disclaimer actually when you're reserving your name that CAMA's CAC, that's Corporate Affairs Commission, still reserves the right to actually withdraw the name. But now it's expressly put in there. How this is supposed to facilitate ease of doing business, well, we do not know. But they just thought they should put it out there so it doesn't seem like a distant or out of the box thing whenever I see the Corporate Affairs Commission does it. So the fact that your name is reserved doesn't mean it is reserved up until the point that I get a certificate. So you may want to submit your final document and then they tell you that the name you reserved has been returned. So you'd have to like reserve another name again. So basically that is what it does. We don't know if this would facilitate the ease of doing business or actually it's just another bottleneck in form of a provision in the laws. But we'll see how CAC work around that, because then many people think now like, so what if I want to just quickly reserve my name, then do my letterhead and all of that, or you have some form of investors agreement that you need to do or some shareholders agreement, and you use the name of the reserved name that you thought that you had, and after some time CAC tells you that it's gonna, like, that's a whole lot of force. You need to go over the same process again, reserve the name and start the whole process. So aside from that, the CAMA now expressly provides for model articles. We know it has always been really, they give you like a default one, a generic one that you can just apply to your business in the event that you just want to adopt the articles that CAC uses. But now CAMA is expressly saying that the minister has the right to actually create model articles, invest the power in them, in writing. It has always been. There's usually a generic memo that comes up whenever it comes to the part of you filling that part during a business registration or a company registration. But now, it's expressly put down in the laws that they do have the power to do that, and in the event that they do that, it's not like they're overreaching or going out of their way or going out of their functions. So apart from authentication of documents, one of the key things I would even like to talk about today is the voluntary arrangements procedure that is now in the CAMA. But before we get to that, there's another more important subject that I like this one because it's a thing that I've seen in various jurisdictions over time. It's disclosure of people that have substantial ownerships in companies. So the thing here is that people would usually like I could be in the shadows and just put like 6 people to get me shares in the company. Those 6 people buy the shares, and at the end of the day, I have like 90% ownership. Nobody knows because I bought in the name of other people. But now, CAMA provides that anybody that has any substantial ownership in a company has the obligation, he owes the company the obligation to actually send notice to them, information about himself, like it is me, I have so percent of ownership, and I would like to inform you. This is because CAC is now going to be keeping a register of persons that have substantial ownerships in companies. So there's going to be a register for them that has their details, and anytime those people file those notices, you're supposed to always contain it in your annual returns. It now has in your company, and that's substantial ownership. And you notify CAC first, and at the end of the year, when you're filing your annual returns, you have to put it there too, so that the information domain is always updated. Basically, what does this do? It's a form of transparency mechanism that is put in play to ensure that people don't just go about amassing control of companies. In fact, it could cause a monopoly. It is very easy for, say, someone with the means to actually break into a sector and buy the ownership of all the major companies there, make decisions in all of them, and it seems like these companies are making individual decisions, but there's a mastermind behind all of it. So those things they want to find a way to curb it, because they could be used as mechanisms for money laundering, fraud, even terrorism financing too. So transparency is going to create more trust in Nigeria's business environment, basically. So even if I as an investor think that, okay, so at least I know those that have substantial ownership, there's a public domain, there are records for it. Even aside from the fact that they are public records, every company is supposed to publish or put it up whenever it is there's someone with substantial ownership. It must be made known to ensure that others know too, members of the public, possible investors, the other members of the company, employees of the company too. So this level of trust actually creates like a soft spot, like a soft cushion effect to the fact that someone, even though I may be planning to take over the company entirely, but then there's notice, so you're like, yeah, maybe he has the means, that's why he's doing it, or he has some form of interest, or he just wants to do it because of the interest that he has. But then you have to give that notice first. So that transparency is actually really since like 2006. There's a whole lot of countries that have incorporated these things, like a whole long time ago, really. Why we're having it now, well, I don't know. So this issue of transparency is such that it's not a one-headed snake. It has like tentacles. There are other areas to it too, like using nominee directors too. There's supposed to be some form of regulation that covers that sector. A nominee director is a director that acts in the stead of someone, like I mentioned earlier. I could be in the shadows and get 6 people, they buy shares in the company or get interest in the company, ownership, and they just act there as directors, but then I'm the mastermind. I tell them what to do. When it comes to voting, they always outvote any other person or outvote members of the company themselves. So that's it. Another end to it is bearer shares. CAMA 2020 expressly prohibits the use of bearer shares by any company. You may ask what are bearer shares now. So let's take it like this. Let me just give it in a very practical way. It's like an open check. Yeah, a check that has no name on it. So whenever it is anybody buys shares in the company or buys ownership in the company, you're supposed to get a share certificate. The share certificate has your name on it and your details. But a bearer share basically gives you that certificate but blank. It just states that whoever it is that's in possession of this certificate is the owner. So anybody, I could get 20 people to get bearer shares and all of them just go all out. One company, and well, we take over. That's that. As a matter of fact, so it's something that it's a very huge step towards transparency and trust. So when any industry, whether it's investment or agriculture, where there is trust, there will usually there's higher level of influx of investors, so to say, because I'm assured that they're using the best practices. and things are as they ought to be. So that would be that about disclosure of substantial ownership. However, CAMA actually doesn't state what amounts to substantial ownership for private companies. For public companies, it says 5% of the unrestricted voting rights. But then, what is substantial could be relative, but I hope we get something to fix that up really soon. So one of the big innovations in the new CAMA are the options that are available to companies that are undergoing the winding up process. So normally the process is that if you run into huge debt, the creditors of the company can actually liquidate that company, sell off the assets, try to get their money back. But if the directors of the company feel like they want to go on, like we believe in ourselves, we actually still have potential. This debt just came off bad. Say for this COVID-19 time now, where some companies may have run into bad debt. So if the creditors and the company themselves believe that, okay, it was because of so thing that we ran into this bad debt and we couldn't repay on time, or we couldn't discharge our debt obligations as we ought to have, they can actually go for other options instead of expressly winding up the company immediately, like liquidating everything. So there are three provided in the new CAMA. There is the voluntary arrangement, there is administration, and then there's netting. I'll be talking about voluntary arrangements because of time. Probably next week we're going to any one of the others. But what voluntary arrangement does is basically a long payment plan for a company. So the company, after deciding that they actually want to go on, they prepare a proposal and then they send it to the creditors. Every creditor, every single person that the company owes money, it must be sent to them. They actually intend to go on with business, and they state how they plan to pay the money back, whether it's an installment or whichever form it is the payment is supposed to come back in the form of increase, whatever. They state it there in the proposal and present it to the creditors. So this whole process is supposed to be supervised by an insolvency practitioner, usually called a nominee. The nominee is the person that usually stays in charge of all of this. And once the creditors receive that proposal, they have a decision to make whether to accept the voluntary arrangement or not. Or whenever it is that the company has gotten a proposal, it's usually filed with the court. You have to file it with the court, and inform the court of the intention of the creditors, whether you plan to have a meeting with them or not. And in the event that you plan to have a meeting, 3 years payment plan, it must be stated there. If it is stated there, then the court has to be given notice too of the decisions that were reached in the meetings. So what that does is that the court is going to give an order. Sometimes the liquidation process may have already been initiated. There may be a winding up process or administration ongoing. So when the court is put on notice, they actually stay those proceedings, like they freeze it till the agreed time for the voluntary arrangement, like till when it's done. So when they do that, the court usually gives a time frame of 28 days before it makes an order regarding the decisions that were reached in both the company's meeting for the first proposal, then the company's meeting with the creditors. So those two, the proposal and that, they must be in sync. Where there are amendments, it must be stated that there are amendments, and the amendment was stated. Every single creditor must be available. I keep emphasizing on that because there's a reason for that. You can't put someone in the shadows or backlash someone, because as at the point of submitting the notification to the court, the notice of reaching a decision to the court gives like 28 days within which anybody can come to appeal that decision was reached behind their back. People that have the right to actually appeal are a member of the company, a nominee, or a nominee that was changed. Nominees can be changed. So the nominee that the company employs can be changed by the creditors to put someone that they feel like is more capable there. The nominees, members of the company, a creditor that feels like he had a right to actually vote at the meeting that was held between the company and the creditors can actually vote too. So after that is done, the court then gives it gives the order that the voluntary arrangement is going to be underway, and whatever plan it is that they choose, whether it's a long-term payment plan, they have to follow it to the latter, follow it all the way. So that's basically pretty much it about voluntary arrangement. There's more in-depth into it, specific details, but I would suggest that before you go into any of that, you speak to an expert first, talk to a legal practitioner, and they will put you through on how you should do that. So I'll keep it there for now because of our time. So I'll go over some of the things that we talked about. We talked about formation, single member companies. One person can now form a company. Authorization of documents, you can use e-sign now, and companies don't really need to use their seals anymore. So your company doesn't need a seal. If your director can sign, or the secretary, or any other officer of the company, that would suffice. There's now minimum share capital as opposed to authorized share capital. Authorized share capital was the maximum amount of shares that a company could issue, while the minimum now sets a benchmark. So it must be at least this. It could go all the way up. Companies can now hold virtual meetings for the annual general meetings. As far as they're in compliance with provisions of CAMA for meetings, that's they must give notices, voting rights, and all of that. It must be in compliance with the law too. I talked about company voluntary arrangements, where instead of winding up a company immediately, if the directors still believe in the dream, they feel like they can still make enough money to pay off debt and all of that. So they could actually reach a concession with the creditors, informing them that, okay, so don't dissolve the company, we'll pay you guys back after a certain period of time. Then there's also a provision for small companies now. So that, I'll quickly touch upon that. I remember that now. There's provision for small companies. Small companies are companies that their net turnover is not up to 120 million naira, and their net asset is not up to 60 million naira. So what do small companies do? It basically gives a flexible way for them to prepare their financial statements, modified financial statements. So they don't need to get auditors and all of that to actually prepare their yearly financial statements, because there's only so much to what they've dealt in. So the issue of what amounts to net turnover and net assets could be questioned. Your net turnover is actually not your profit. There's a difference between your net turnover and your profit. The net turnover is basically everything that your company made in a financial year. It's what you get from your major trading activities. So money that you get from other sources, like say a loan, is not going to be part of your net turnover, or some form of investment is not going to be a part of your net turnover. Net turnover is every, let's say you are dealing in diapers, for example, or mobile phones. Your net turnover is the total amount of mobile phones that you sold for that year. So it differs from your profit, because your profit is what you get after you deduct some form of expenses. The whole issue of EBITDA and all of that would come in, but those are more on the financial side. But then, from your net turnover, when after deducting the cost of your goods sold, you get your net profit. You get your gross profit actually. Then after removing other expenses like taxation, amortization, depreciation, you get your net profit. So your net turnover basically just gives like a general overview of everything that you have made, everything that has come in from your major activities, your major trading activities. So that's about the small company. So you can do modified financial statements. You don't have to get auditors, because it's quite pricey. So to say, a company that is making like 800,000 naira per year, you expect them to get auditors to prepare their financial statements and all of that. They will probably put in like half of everything they've made into doing that. So it's a good one, because now there's going to be thresholds. They recognize that this company is a small company. It just provides for small companies. We don't know if they are big or medium companies, but that suffices, because many companies actually fall within this basket, and it's going to help them to facilitate. So far, so good with the CAMA 2020. We think it's a good one, because it's baby steps actually. We'll get to where we ought to be, but it's really a good one, because most of the innovative provisions that have been put in, they put in them there because they understudied other nations that had such practices. so those provisions in their own Companies Act, be it what they call it, whatever it is they call it. So it's like fail safe to an extent, because laws keep changing, the way things get disrupted, there are technological advancements and all of that. So over time, I'm sure very soon we'll still get another modified version, but it's just going to be maybe major or minor amendments here and there that will be tweaked to meet some certain criteria. But it's a good one so far. Having wonderful ways of doing it, it helps the economy, even though it may seem on the face of it that, well, it's just the ranking and all of that. But when you have that, when you get more investors into your economy, it's a whole lot for small businesses, medium, even for large businesses too, large enterprises. So I will keep it as that for now for this week. Next week we'll be having some other major highlights, like the issue of limited liability partnerships. I know many people want to actually listen to that one, because they're like, okay, we know about partnerships. What is it with limited liability partnerships? They sound very, very, I don't know. It's like pretty cool. Like, that's the word. I don't know if it's cool, but yeah, we'll keep it at that. So we'll see you next time. That's next week, same time. So have a lovely day, right?